Hi, I'm firearms attorney Gilbert Ambler, and I'm back today because here in Virginia, although we're not in a national election year, we are coming into the end of September, October. We are in full-on ramp up for a very important state election this year. And one of the things that's going to be decided is control of the governor's office. Now, there are many people in Virginia, and I'm not opining on which way this election is going to go. I am not a fortune teller. I have no idea. I can't read the crystal ball and tell you what's going to happen in this election. There are many people out there saying this is an important election, and I agree with them. And one of the reasons I agree with them is that in Virginia, we have seen gun bans being passed by the House and Senate over the past couple of years. Now, they talk about common sense gun control and reasonable gun control, but the truth of the matter is the legislature in Richmond, as it's currently made up, with the exception of the governor, our current governor, Governor Youngkin, the legislature in Richmond seems to have not met a gun restriction that they're not willing to pass. They have passed, now it has not become law, and it has not become law thanks to Governor Youngkin vetoing these proposed restrictions. But the House and Senate have passed restrictions on everything from assault weapons to the age that you could buy a firearm, restrictions on 18 to 20-year-olds possessing certain firearms, to waiting periods for firearms, to additional gun-free zones, all sorts of nonsense. But what we want to talk about today is the risk of an assault weapons ban. Because if Virginia's November election goes poorly, there is the risk that there might be an assault weapons ban passed in Virginia. And if that's making you a bit nervous, perhaps you have some things that would be assault weapons under the laws that have been proposed in the past, I want to talk with you about potential solutions. And of course, we have the opportunity right now in the lead up to the November elections to get involved and to vote. And so I'd encourage everybody to get involved, talk to your friends, talk to your neighbors. If you're eligible to vote, you should be voting in this election. But we can't control the outcome after it all happens. After the cards are played and the election happens, if we lose this election and an assault weapon ban is passed in Virginia, what would the ban look like? And what options would you have to respond to it? Before we dive into this subject, if you have not yet hit that subscribe button, what are you waiting for? Hit subscribe, like, comment with your thoughts, and share with your friends. That way you and your friends can keep getting this important Second Amendment related content. Let's first talk about what past assault weapons bans that have made it through the House and the Senate in Virginia have looked like. Because these have been passed in 2023, 2024, or at least 2024 and 2025. I have to go back and check 2023. But in 2024 and 2025, these bans made it through the legislature, but were vetoed by the governor. So what do the bans look like? Well, they're what we would call features bans. And when I say features bans, what I mean is they are not bans that other states have tried where they simply list weapons by models. You can't have an AK-47, an AR-15, a Ruger Mini 14, etc. That is a assault weapons ban that lists specific weapons, and sometimes there's some workarounds for those bans where you can find weapons that are not on the list. Very famously, there are states that banned Colt AR-15s but did not ban the heavy barrel Colt AR-15. That's an example of a workaround. That is not the approach that Virginia has taken in the past. What Virginia has done is a features ban where they say if it is a semi-automatic centerfire weapon, they've got bans for both rifles and pistols, that has the ability to accept detachable magazines and then any one of these features, things like pistol grips that protrude below the stock, flash hiders, muzzle brakes, grips or shrouds, second grips, a second grip for the non-trigger hand, etc., then the weapon would be prohibited. Now, the bans that they have passed in 2024 and 2025, at least, and again, I'm saying passed because they went through the House and Senate, not because they became law. Again, thanks to Governor Youngkin for the veto. The bans that have been passed, when they did this, they exempted weapons that were already owned. So it was a ban on the sale, the transfer, the renting, etc. It was not a ban on possession alone. So you could still possess those weapons if you already owned them. So coming into November, that's one thing you may want to think about. If you've got your eye on a weapon and you want to own that weapon, you might want to buy it in case this election goes poorly, that way you already own it. That way you can continue to possess it if they pass a ban that allows continued possession but would not allow the sale. So that's one thing to start thinking about. But what if it's worst case scenario? What if they take the position like some of those other states have where they ban the possession of items that you already own? Well, we have some logistical hurdles to a constitutional challenge to such a law because here in the Fourth Circuit has already upheld Maryland's assault weapons ban. Maryland, in the Fourth Circuit, looking at Maryland's assault weapons ban, said that items that were too militaristic did not get Second Amendment protection. And I think that's backwards minded. I think that's an erroneous view of the Constitution. And it's something that I hope the Supreme Court of the United States addresses. But until they do, that's case law we have to live with. There is, of course, still an opportunity to challenge the constitutionality of any such ban, and it could be challenged under Virginia's Constitution, Article 1, Section 13, which is Virginia's own version of protection for the right to bear arms. And of course, we have a different historical tradition here in Virginia. Virginia's original protection actually dates back to 1776, which predates the Bill of Rights, which was the United States Bill of Rights, which was 1791. So there could be a state-based constitutional challenge. The other thing that you might want to think about is if such a ban were to be passed and it banned possession, a constitutional challenge could take months or even years to be resolved. What would you do with your weapons during that time frame? And many of you might think, well, I will simply give them to a relative that lives out of state in a gun-friendly state. Maybe I've got an uncle that lives in West Virginia who would store those firearms for me. And this can probably be accomplished, but you have to be very careful. And the reason you have to be careful is that federal law, 18 U.S.C. 922A5, generally prohibits the transfer of a weapon from an individual to a resident of another state. What 18 U.S.C. 922A5 allows is it allows a temporary loan for a sporting purpose. So if your uncle wanted to use your rifle to go target shooting, that would be allowed, but he can't necessarily just indefinitely store the rifle to you. Now, there might still store the rifle for you, rather. However, there might still be a way to accomplish this, and the way that you could potentially still accomplish this is you could consider, again, if you had a relative in a gun-friendly state, you could consider putting the firearm in the relative's house, in the gun-friendly state, stored in a manner that the relative did not have access to it. So in a gun safe that only you could access, stored outside of the state. And by doing this, you would still have possession of the item, but not possession of the item inside Virginia or inside the state that might be banning that item, and thereby you might be able to avoid criminal penalties because the state wouldn't have jurisdiction because the possession is not occurring within their borders. Now, if you didn't have a relative, you could even consider something like a storage locker. And again, this is not intended to be broad-based legal advice. You should consult with an attorney if you are thinking about doing this, and consult with an attorney knowledgeable on the state that you're thinking about storing the item in. But in many states, there is not actually a restriction in renting a storage unit and putting weapons inside the storage unit. Now, the storage unit might have policies prohibiting that, but the law generally doesn't prohibit that. And so that may be another possible workaround here where items could be stored out of state while a constitutional challenge is pending. Now, I hope none of what I'm talking about today comes to fruition. I hope it's all unnecessary. We don't need to worry about it. The election goes well for gun owners, and we get to retain all of our rights. What I want you to start thinking about is what you're going to do in case the election doesn't go well. And in the meantime, I want you to engage with your family, with your friends, with your coworkers to encourage people to go vote. If you enjoyed this content, go ahead, hit that subscribe button for us. Until next time.